First District Court of Appeal is now in session. All who have business before this court, draw near. Give attention and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Good afternoon. We are here in case 20-1165, Zurich versus Steele et al. I've been informed that counsel for all the parties are present, and I think I see everyone's faces. Before we get started, I did want to follow up on an order of the court relating to questions for respondent Thornton Tomasetti. To the extent the panel has any questions for counsel for Thornton Tomasetti, we will ask them of you after counsel for Zurich completes his argument. And if we do have questions, we will, of course, extend the time on the respondent side accordingly. So with that, I will turn it over to counsel for the petitioner to begin when he is ready.
Yes, ma'am. Thank you, Your Honor, and may it please the court. My name is John DeRevere from the DeRevere Stevens firm. I am here on behalf of the petitioner, American Zurich, who we will call Zurich, as we all know, is the insurance carrier. And I would like to reserve 3 minutes of my time for rebuttal, if that pleases the court. I was asked to let the court know that Ms. Williams is here on behalf of Thornton Tomasetti. She had indicated to us earlier that she does not have a presentation to make, but we wanted the court to know, and obviously I think the court does know, that Thornton Tomasetti effectively adopted Zurich's position, and therefore she should be on my side rather than on their side, for whatever that's worth. Zurich respectfully would request that this court would grant certiorari relief and quash the stay order that is the subject of this matter. A few facts are significant and important. The case arises out of a partial collapse of the Navy Federal Credit Union building back on August the 26th, 2017. The injured workers in this case were working on the building and were injured as a result of that partial collapse. Zurich is the workers' compensation carrier and is only here in the capacity of being the workers' compensation carrier, not here as the liability insurer for the general contractor. And it becomes important, the distinction between those two different shoes to fill. The facts are clear that Zurich sent out a notice of intent under the 44039 statute in August, on August the 2nd of 2018, and Zurich filed suit. We believe the facts are clear on September the 3rd, 2018. The injured workers, now some injured workers filed before Zurich did, and obviously under 44039, they can proceed with their cases, and Zurich is only entitled to a lien under 44039.3, a manfredo, and I think we're all familiar with that, and kind of leave that to the side for a second.
Counsel, a quick question for you. I know the petition, you spent a lot of time talking about the statutory interpretation question below, but I'm struggling with trying to decide how that is relevant to our analysis on cert review when I believe the order before us is the one on the stay issue.
You are absolutely correct, Your Honor. And what I was going to end with, frankly, is that we'd like for you to accept the cert, quash the stay, and then do what you think is reasonable and appropriate. I mean, obviously, the big issue in this case is who has standing. And the whole point of being here, for at least for Zurich, is to try to tee up the question of whether it is the Santa Clara and the Waters Cruise folk have standing, or does Zurich have standing? And
let me ask you about the standing question, counsel, because couldn't you have raised that after Judge Bergosh did the order on the motion to dismiss back in 2019? No. You weren't a party there, but you didn't move to intervene. You didn't move to consolidate. You argued the case for Hensel Phillips, I believe. So obviously Hensel Phillips could have tried to pursue some sort of appellate remedy at that point. So how is Zurich then exposed to irreparable harm that can't be cured on appeal?
Your Honor, Zurich was not patently not a party. And whether I argued or not as sort of a friend of the court, I clearly got in front of it to try to make that assertion. But the court, Judge Burgash made very clear that Zurich was not a party in the injured workers cases. And
isn't your remedy at law, though, to move to intervene and become a party in those cases?
no, because Your Honor, the problem with an intervention for a workers' comp carrier, and I'm not aware of any case where a workers' comp carrier has been allowed to intervene to pursue its own claim. A workers' comp carrier can certainly intervene to pursue a 440-39 lien claim. You can do that, but then the intervention, by its very definition, you are derivative to the primary claim. If we had done that, that would have just been an affirmation that, in fact, we were not entitled to our own recovery, that we were only going to be entitled to a 440-39-3 lien recovery. And so we had our own case in chief. We always had our case in chief. And frankly, we had the first case. If they wanted to intervene, they should have intervened in our case, not we intervened in their case. So our position is, both procedurally and substantively, it would have been inappropriate to intervene in their case. We asked the judge to make that order applicable in Zurich's case. He refused to do so. So at that point, no, I don't believe there would have been a basis to take certiorari appeal from a motion to dismiss. It is, in fact, because, well, again, how would that have ever been not curable on a final appeal if we had been in the case?
Well, isn't
Well,
it
let
the
me
same-
ask, go ahead, Judge Bilbrey. No, please, Judge
Isn't it the
Bilbrey.
same situation here then, that this could be cured on a final appeal? Where's the irreparable harm that can't be remedied on appeal?
Because it's a stay order, Your Honor, and that's what we're here for, is the stay. The stay basically creates a situation where there are two different, completely mutually exclusive claims going at the same time. And I think that the teaching of the Supreme Court is very, very clear under Kimbrell versus Page and Aetna versus Bartz. Kimbrell is at 448 Southern 2nd, 1009. That's the Supreme Court 1984. And Aetna versus Bartz is at 271 Southern 2nd, 108, Supreme Court 1972. That there can only be one case at a time for the injured worker's recovery. So the difficulty with the stay is that there's no contingency that Zurich is capable of overcoming. It's for an indefinite time and for an indefinite purpose, which is to say, presumably, that the only way that the stay goes away is once there's a final judgment or a settlement on behalf of the injured workers, at which point there's nothing left to argue. So that is both the irreparable harm and, on its face, the failure to comply with clear edict of the law.
So Hensel Phillips will certainly have full appellate rights after the judgment is entered in the injured workers cases. Why is that not sufficient? I mean, it was certainly sufficient, as it was Hensel Phillips argued this issue below. They weren't successful, of course, but why could they not raise this issue on appeal on Zurich's behalf or on its own behalf?
Well, Hensel Phelps could do anything it wants, Judge, but Hensel Phelps has a different interest in the case. Maybe they'll settle, maybe they'll get out on summary judgment, maybe they'll try the case, maybe they won't. The fact of the matter is that Zurich has an independent right under 440-39 4A to seek relief, the relief that it is looking for here. And so to rely on a different party, I mean, if that is ultimately going to be the question, that, a party can rely on some other party hypothetically to do whatever it is they want them to do. Again, the plaintiffs in this case could say, well, the Santa Clara plaintiffs could just say, well, I'll rely on somebody else to do all that stuff. Maybe you can, maybe you can't. But ultimately, Zurich has a right under 440-39 4A that Hensel Phelps does not have. Now, the standing issue is similar. There's no doubt about that. And Zurich is Hensel Phelps' insurance carrier, but we all know that Zurich is not a party and cannot be a party because of the non-joinder statute to Hensel Phelps' claim, whatever that might be. Hensel Phelps is the client there, not Zurich. Zurich.
Given that Zurich has a comp lien, where's the irreparable harm? Zurich, given that there's a comp lien for Zurich, where is there irreparable harm, given that if the plaintiffs have a recovery, the injured parties have a recovery, Zurich would be made whole?
Well, Zurich won't be made whole, and that's the cases are very, very clear, Your Honor. And I'm not sure if Your Honor really knows the difference between a Manfredo equitable distribution situation, which is really what we're fighting about.
Well, I am aware. I've read Manfredo, but you didn't cite Manfredo until your reply brief, so it wasn't argued in the petition. So is that even properly before us?
Well, I think surely under 440-39-3, Your Honor, that is the equitable distribution statute, and we certainly raised 440-39-3.
But did you raise that there would be some different pro rata recovery in your initial petition? I didn't see that.
No, we didn't, Your Honor, but I think it's very clear that the difference between getting 100 cents on the dollar under 440-39-4A versus getting whatever an equitable distribution is under 440-39-3 is substantially different. And that just is the known law in the state of Florida and has been. And that's really the fight here, is that ultimately, and this is obviously why the respondent injured workers want this to be a 440-39-3 case rather than a 449-4A case, because their recovery potentially is much, much larger. They won't have to pay 100 cents on the dollar on the lien. That's really what the fight is about here.
I want to next turn. Let's just assume we can get through the jurisdictional prong, the irreparable harm, and we move to the departure from the essential requirements of law.
Absolutely.
So the petition seems to take two paths on that. One arguing that we need to consider the law on stay and whether the court abused its discretion in that regard. And then the petition also argues, again, the statutory interpretation issue. So can you kind of help me tease out what issue is teed up for us to determine whether or not there has been an essential departure from the requirements of law?
Sure. Clearly, it's the stay, and the rest of the stuff is kind of behind it. The stay is clearly a departure from the essential requirements of law because, first off, there's no contingency that Zurich can have any effect upon, and that's the Shoemaker case that we cite. Shoemaker versus State Farm is at 840 Southern 2nd 1195. That's a 5th DCA case from 2005. It is also the second case as opposed to the first case, and so we cited a Supreme Court case back from 1941 that essentially says, you can stay the second case, but you can't stay the first case. But in this case, even more so. The problem is, going back to a Star Trek reference, this is like matter and antimatter. One party has standing. So be it. If the injured workers, if we have to wait until the 366th day as the comp carrier to file the notice, and then we have to wait 30 days after that. I mean, we can argue about the statute and what it means. And Judge Vergosh accepted their position. That's fine. We'll eventually get there, hopefully. But you can only have one case at a time. And that is ultimately the problem, is you can't have the matter and the antimatter simultaneously of saying we've got two cases and then maybe someday something will happen to make one case stay and one case go. One case has to go under Kimbrell and Aetna versus Bortz from our position. I'm down to my 3 minutes. Unless the court has a specific question for me, I am going to, I would say sit down, but I'm already sitting. I'm going to pass the baton to Mr. Moxon unless the court has a specific question for me right now.
I don't see that we have any additional questions for you at this time. I did want to ask the panel if they have any questions for Ms. Williams on behalf of Thornton Tomasetti.
I do not, Chief. Thank you.
Okay, hearing none, we will turn it over to Mr. Moxon on behalf of, I don't know if you're arguing on for both respondents' side or if you decided to split your time. What is counsel elected to do?
I will argue for the respondents unless the court has any questions for Mr. Gore, who's counsel for Mr. Cruz and Mr. Waters.
Okay, understood. Thank you.
Thank you. May it please the court, Shay Moxon, Brandon Humphreys, and Berman, on behalf of the Santa Clara respondents, and as I just said, all the respondents. Essentially, there are two main reasons why the court should deny Zurich's petition. First, there's no irreparable harm because the only form of harm that Zurich alleged in its petition is that it's unable to get immediate appellate review of Judge Bergash's order that denied the motions to dismiss the injured workers' cases. And second, there's no departure from the essential requirements of the law because Judge Bergash acted within his broad discretion to stay Zurich's case as being duplicative of the injured workers' cases in order to promote judicial efficiency.
Mr. Moxon, how does Zurich get appellate review, immediate or otherwise, of the statutory interpretation question?
It's, well, at the conclusion of the injured workers' cases, it can appeal on behalf of its client, its insured Hansel Phelps. Then also the stay would be lifted of its own suit at that time. If there's a ruling at that time, they can appeal then. Either way, the appeal should come at the end of a final order. This is a classic non-final ruling that needs to wait for a final judgment to be appealed. This ties back to my irreparable harm argument. As Judge Bilbrey pointed out, the things we've heard today about different distributions was never raised in the petition. The only form of harm they alleged in their petition is classic things that courts have said over and over are not sufficient grounds for certiorari relief. That as a result of this stay order, the injured workers' cases are going to go forward to final order. They're concerned that there's going to be uncertainty about how, when an appellate court might decide later on. And so it might all be for naught if this court later decides that Judge Bergash got it wrong. That's at different points in their petition, pages 23, 33. They're clearly arguing that the harm here is that, the injured workers' cases are going to go forward and take up time and judicial resources.
One of the harms they alleged in their petition was this Infonet contracting, which talks about the possibility of inconsistent, verdicts, inconsistent dispositions of the cases. Is that present here, given that these cases are still, although they're consolidated for discovery, they're separate cases?
No, there's no risk of inconsistent outcomes for two reasons. First, all the cases have been consolidated in front of the same judge, the same trial judge, Judge Bergash, every case arising out of this collapse. And second, Zurich's case has been stayed. One of the purposes of a stay when there are two duplicative cases is to avoid the possibility of inconsistent outcomes, and that's been done here. So even if down the road there's some judicial reassignment, the stay prevents the possibility of inconsistent outcomes. So as I was saying on the irreparable harm issue, it's classic that the time and expense of proceeding to final judgment, the possibility that a case might have to be tried twice, the very same things that they argue in their petition, litigation of a non-issue, all these things are insufficient to amount to irreparable harm that will support certiorari relief. And so that's the very reason why an order denying a motion to dismiss is rarely reviewable by certiorari, only in very limited instances, say if they involve sovereign immunity, and even then there's some limits there. I might have even gotten that wrong. So, and all throughout the Zurich's petition, it's really an attack on Judge Bergash's order denying the motions to dismiss the injured workers' suits. It argued several times that that was an erroneous ruling, that our suit should have been dismissed. It copies and pastes for pages throughout the petition. So this is really, they've raised this as a collateral attack on that order denying the injured workers' suits. It was entered long before they filed their petition, at which it wouldn't have been reviewable by certiorari in the first place because there's no irreparable harm. And that's all the more true when they didn't even file their petition until several months after that order.
Counsel, you mentioned that I guess one perhaps the scenario is that the injured workers lawsuit, goes to final judgment, but that Zurich could appeal the dismissal of its case. But what does that appeal look like at that point if there's been a final judgment already entered on the injured workers' cases?
Well, they would argue that it shouldn't have been dismissed because its case should have been allowed to go forward. But also, that appeal might never be necessary because, as we've discussed, and I believe Judge Bilbrey mentioned, they have a lien on the injured workers' recovery, and depending on how much is recovered in the lawsuits, whether through judgment or settlement, all this might end up being a moot question. They might get all the compensation that they need. And as Judge Bilbrey pointed out, the argument that they raised in the reply brief for the first time about there being different formulas and Manfredo, they never raised that in their initial petition. And an argument raised for the first time in a reply brief is not cognizable on appeal or in a certiorari proceeding. And even still, I believe that even if you get past that point, I believe Zurich would be able to appeal an adverse distribution if they're aggrieved by it and if they can show some legal error occurred in that. I haven't researched that because, again, Zurich never raised this in their petition, but it seems like, if at the end of the injured workers' cases, they believe there was some error in the amount that they were awarded, perhaps that could be appealed. And something similar happened in the Aetna v. Bortz case.
The Santa Claras had sued Hensel Phillips for an intentional tort, as well as I think there's some loss of consortium claims for the spouse and minor children, and maybe some other claims too.
Yes.
How are those, if we were to agree and if their action were to proceed, if Zurich's action were to proceed and the injured party's actions were to be stayed, what would happen to the intentional tort claim and the loss of consortium claims?
Well, that is a good question. And your question goes to show why this immediate appeal that they want would not actually resolve all the issues that we have in our case. I don't believe that Hensel Phelps is entitled to rely on this two-suit thing because Zurich never sued Hensel Phelps. It's doubtful that Hensel Phelps even qualifies as a third-party tortfeasor. And if Zurich suits goes forward, I don't see any reason why that should bar these loss of consortium claims. So I'm not sure if that answered Your Honor's question, but
I guess it would be your understanding that those claims would be permitted to proceed potentially in another forum, whether before Judge Burgash or some other separate suit?
Well, I'm thinking hypothetically, suppose Judge Burgash went the other way and said, and ruled Zurich commenced their suit properly and ruled against us in that respect. I think even if that were true, that shouldn't bar our claims against tortfeasors who were never named in Zurich's suit or the loss of consortium claims. If that answers your
Yes,
question.
thank you.
And which all goes to show that that even this appeal that Zurich wants to take immediately, it wouldn't resolve all these issues anyway. But I want to tie it back to the main point. They have not alleged any cognizable form of irreparable harm. What they've alleged in their petition is that this stay order is allowing the injured workers' suits to go forward, and it might all be for naught. Those are the same kind of arguments that people have unsuccessfully raised to challenge a denial of a motion to dismiss, and it's not grounds for certiorari relief. And unless the court has any more questions on that, I can discuss why there was no departure from the essential requirements of the law in granting this stay. Of course, trial courts have very broad discretion to stay duplicative litigation that have overlapping parties and issues. They don't have to be perfectly identical parties and issues as long as they're substantially similar. And Zurich they're absolutely incorrect that only a second filed case can be stayed. The cases that they rely on involve when they're pending cases in two different states or two different circuits, In those situations, there are interests of comity, meaning deference to the other jurisdiction. But when there are two cases pending at the same time in front of the same court, that doesn't apply. And we've cited cases in our response at our authority for staying the first file case when the circumstances warranted it. The Mendez case, where the Miami-Dade Circuit Court, they stayed a case in Miami in deference to an action pending in Brazil. And the footnote even notes that the Florida case was filed first. Maresca versus Allstate, it talked about how when you have two replevin actions for the same property in the same court, either one of them can be stayed. And it discusses that the trial court correctly ruled that the second one was the appropriate one to go forward. So there's authority for staying the first of two duplicative cases when the circumstances warranted it. And Judge Burgash, in his discretion, found that that was the appropriate remedy here. And that would serve the interests of judicial economy to avoid, all the disruption that an immediate appeal taken by Zurich might cause. Additionally, Mr. Deravere keeps referring to this as an issue of standing, but it's not really a question of standing here. It's a matter of whether they comply with their condition precedent to file suit, whether they commence their suit properly.
Do we need to determine that issue to determine whether we have certain jurisdiction here? Do we need to look at that ultimate issue of who owns the suit? I think was how Zurich put it.
Well, I don't believe you do. I think it's enough that Judge Burgash looked at all the circumstances, the fact that Zurich's suit is duplicative of I think 5 other suits, and each of those is only duplicative of one Zurich's. Consider the effect of disruption that would be caused if there were a dismissal of Zurich's suit and an immediate appeal that would put all these different cases and pieces of cases on different tracks. And although Judge Burgash's original conclusion about that they failed to comply, and that certainly informed its decision, but I don't think the court needs to review that. I think it's enough that Judge Burgash had a sufficient reason to exercise his discretion in favor of a stay, and particularly when there's no case law addressing such an unusual circumstance here, where there's a body of law that sets up a race to the courthouse, and in this unusual 440.39 context, with no case law on point, it can't be said that he violated any clearly established principle of law to depart from the essential requirements of the law. But I am very happy to defend the fact that his ruling that Zurich did not commence a suit properly, that was not a departure from the essential requirements either, if the court even reaches that issue. And if the court has any questions about that, I could proceed to address that now. Well, I'm not hearing any further questions from the court. I'm glad to address any issue concerning Zurich's failure to establish irreparable harm and the fact that Judge Burgash did not depart from the essential requirements of the law in ordering a stay, or in his initial ruling, which I don't think the court should reach, but even if it does, he didn't depart from the essential requirements there either. So unless there are no further questions, we just ask that Zurich's petition be denied.
Thank you, Mr. Moxon. I will return it to Mr. Deravere. I hope I pronounced that correctly.
You did great, Your Honor. It's a tough one, but I didn't choose it. Thank you. First off, let me answer Judge Bilbrey's question. I believe that under the law, although we didn't cite it, it is a true thing to say that the claim for the carrier, workers' comp carrier, would be for the injured worker and not for the consortium claims or the claims of his children for those derivative claims.
So those derivative claims would still proceed separately, as well as any intentional tort that they would do?
Well, I'm not sure about the intentional tort. I think that Zurich would own Mr. Santa Clara's claims, whatever they might be. I think that's how the statute is set up. the statute is very clear that it says that all claims, if the injured worker fails to bring suit against the tortfeasor after giving notice of the claims, his or her dependents, if represented, shall institute against such third party. So I believe that it would likely be all claims of Mr. Santa Clara. I don't think you would separate them out. I think that there's some case law that says that counsel for Santa Clara can be a part of that proceeding in a 4A proceeding, but Zurich would own the claim of Santa Clara. It is a standing question. I would respectfully disagree with my colleague, Mr. Moxon. And under the Supreme Court case law, under both Kimbrell and Boards, again, I use the Star Trek reference, matter, antimatter. You can't have two cases going at the same time, and that's why a stay is inappropriate. One case goes, the other case has to be gone, and that's what Kimbrell has decided, and that's literally, I think that the case law is very clear. And in terms of the difficulty here, again, the problem for Zurich is that by design, in effect, unfortunately, the way we've got it is that Zurich is not a party in those cases. And the only way for Zurich to be a party in the injured workers cases is, again, to state derivative status as an intervener, not as
counsel. Real quick, just to clarify, Mr. Moxon stated that, you know, essentially Zurich as the liability insurer would be able to appeal on behalf of its client, Hensel Phillips. And it also stated that in its response on page 20. Is that accurate or not accurate?
Zurich cannot do anything as the liability carrier, not a party. Hensel Phelps gets to do whatever it wants to do. But Zurich is a completely different entity with completely different rights as the workers' comp carrier, statutorily. There is no basis for Zurich to take an appeal as Zurich anywhere because of the non-joinder statute. And so he is incorrect that that would happen. Again, you know, the problem with this case is that this particular stay creates contingencies that are completely outside of any ability of Zurich as the work comp carrier to change. And that was the situation in Shoemaker versus State Farm at 890 Southern 2nd 1195, that 50 CA. And just let me read just quickly from it. A stay postpones an action until some contingency occurs. Here, the trial court's order has the effect of postponing Shoemaker's action until two district courts of appeal resolve unrelated cases decided on different theories. The stay entered in this case is indefinite and dependent on matters over which Shoemaker has no control. When the pending appellate matters involving State Farm will be resolved is anyone's guess. Consequently, the stay entered here could lead to excessive delay, something not capable of being remedied on direct appeal. And again, given Shoemaker's age and health, and it says we conclude the circuit court should not have granted the stay because Shoemaker is not a party to the two other cases now on appeal, which is essentially what we have here. Zurich is not a party in those other cases, has no right to control those cases as a direct party, and the outcome of those cases could be settlements, could be judgments, and by the time you have a judgment potentially in favor of the injured worker, that's res judicata. And then we're right back to the Kimbrell case, which says, all right, well, now it's over and the horse is out of the barn and all of this has happened. And Zurich, you're just out of luck. You get what you
Counsel, thank you so much. You have run out of time, but we appreciate the thorough arguments of all the counsel involved today. We will take the case under advisement. The court is now adjourned.
Thank you.
Thank you, ma'am.
Thank you.